Me like you would be a fun and interesting attorney to work with, even though I haven't actually worked with you. So it was part of why I wanted you particularly to come on.
Well, thank you. I think the understanding comes from spending 25 years watching families plan and families that don't plan. And you know, many of the things we'll talk about today are based on what if you don't. What very few people talk about is what if you do the planning. And what we see is the stories out there are about the bad news, the family that didn't have the right legal documents, and the disaster in the probate court, or the disaster with this trustee or that problem. What you don't hear about are the successes, because the successes occur quietly at a very bad time for people. And so for my clients, things go as well as could be expected given a really bad circumstance. When I'm working on other matters for people who were not clients before the disaster occurred, hopefully they think the process was reasonable, but it is painful when you don't have the right framework for your family.
Okay. Now, I would think the first thing that pops to my mind when I think of estate planning is wills. Does everybody need a will?
Does everybody need a will? Well, it's hard to say broad brush yes or no.
Okay.
There are documents everybody does need.
Okay.
Arguably, not everybody needs a will, but almost everybody. Okay. I suspect your 19-year-old child, while legally entitled to draft and sign a will, probably doesn't need one. But certainly every adult, every working person, married, single, kids, no kids, sure, you should spend the few minutes it takes to tell the world what to do with your things if you're no longer here.
Okay.
Simple as that.
What are the documents you say that everybody needs, absolutely needs? Absolutely
needs. Everybody over the age of 18 is confronted with today's reality as it relates to privacy laws. Massachusetts and the federal government have extraordinarily tight privacy laws. People can't talk about you to anyone any longer. I know that in the mail I am getting endless privacy notices from my credit card company, from my investment house, from everybody. When you go to the doctor's office now, you sign some form at the front desk in a big clipboard. You don't really know what you're signing, but it's a privacy law notice. So now in my world, if somebody's disabled, whether it's a 19-year-old child or a 45-year-old husband or wife, nobody can talk with the doctors. Nobody can talk to the banker or the stockbroker unless they have signed certain key documents. The healthcare proxy, the durable power of attorney. Simple legal documents that delegate from you to someone else legal authority over medical issues or financial issues. Without that, in some cases, doctors in an emergency room won't talk to spouse, surely won't talk to children unless you have the signed legal documents. The penalties.
So to review so far, the will for almost everyone,
right.
The healthcare proxy and the durable power of attorney for, again, everyone.
Everybody.
Yes. And one of the things that we know is having those documents is step one. And for the durable power of attorney and the healthcare proxy, letting people know that you have them, getting those copies to doctors' offices and hospitals and
right.
family members is critical.
Absolutely.
Yes?
I think you're absolutely right. You need to get the documents signed. I always want a copy of the healthcare proxy to be in your primary care physician's files. If you have other physicians or you know you're going into the hospital, surely you would send them a copy. What a lot of people do that is, I think, a serious mistake is they take those emergency documents and they put them in their safe deposit box. Now on a Sunday morning when there's a crisis, they can't get at those documents. Those are not documents to go in a safe deposit box. Copies at home, originals at home, but surely not in the safe deposit box.
So I'm all alone by myself on Sunday morning, and I need to go to the emergency room. I don't have my healthcare proxy with me. It's in a file drawer or something. So when I come to the emergency room, what happens?
They'll ask you if you have a healthcare proxy, and
But
you'll say yes at home in the desk drawer.
Okay, and
So-
they'll often make me sign it again.
Right.
Another one.
Well, they can't. And that's a misconception. Under federal law, they must hand you an information package about your rights to sign a healthcare proxy. But a healthcare proxy requires 2 witnesses. Hospital employees are not allowed to witness. So you're in a bit of a bind, and of course, if you're not mentally able,
Right.
then that doesn't work at all. I would suggest that people keep their envelope with their key legal documents somewhere really easy to grab in an emergency. And if you call the ambulance, perhaps there's a note on the refrigerator, emergency papers in the top desk drawer or in the freezer, someplace where it's easy to grab them and take them with you.
Could you, I've never thought of this before, could you shrink them down,
Yeah.
laminate them, and carry them?
Yeah, you could.
Yeah.
The healthcare proxy, as I draft it, runs on for 6 or 7 pages. So that's difficult
that's
to shrink
difficult.
wrap.
Yeah.
But if your physician has a copy in their medical records, if the lawyer has it and has scanned it and can email it someplace, the window closes of the times when it could be a problem. But surely if you travel, make a photocopy and put it in your suitcase with you,
Yeah, or email it to yourself,
wherever you're going to be, and keep it in your
keep it in your
right.
PDA or
Right.
something.
Right, absolutely. That is not the case with the power of attorney. Power of attorney is about financial matters. We can go several weeks without needing to run around and deal with the power of attorney. So that document doesn't have quite the sense of urgency.
Right. But the healthcare proxy does. right.
Absolutely.
And the HIPAA document.
Yes, HIPAA, which is the new federal privacy law, all of the power of attorneys and healthcare proxies that are more than 3, 4, 5 years old are not HIPAA compliant.
Right.
So what I have my clients do is sign a 1-page HIPAA document that incorporates them and approves them, but all new documents are HIPAA compliant. Interestingly enough, most of the HIPAA, the healthcare proxy forms that the hospitals give out are not HIPAA compliant.
And most of them are witnessed by hospital employees.
Right.
You
Oops.
grab a nurse and you grab somebody
Right.
who's doing something else.
You
and
do the best you can
you
in
do
a
the
pinch.
right in
Right.
a bad situation, and
Right.
often what you originally wanted or the person you originally wanted is never
Right.
is not to be
Right.
found. So it's probably advisable if you're, let's say, over 18, or you have a lot of, you don't have a lot of, you don't care about who gets your things if you have a will. So you'd advise most people to have a will.
I think people should have a will. I think we all have things that we should direct to somebody. If you don't have a will, Massachusetts law tells us who will get your things. And that's, parents first and then siblings, of course, children if you have children, children, spouse, but then parents and siblings and on out the family tree. But the act of doing a will forces you to focus your thoughts, because where you need to put some energy is on a related asset, which are the assets that have beneficiary designations. If you don't do a will, that means you're not sitting with somebody to think through who should be on my IRA beneficiary, my Roth IRA, my group life insurance at work. There are endless places where a pre-printed form needs to be filled out, and that pre-printed form controls everything. Your will does not have the ability to change that. So there are many cases where husband age 45 will pass away. The IRA beneficiary names his mom because he opened it when he was 26. Now he's married with 3 kids. Mom died 10 years ago. That is a classic disaster that doesn't need to be. Or the people who get divorced and don't update their beneficiary forms. The ex-spouse will get those assets. And so virtually everybody who's employed has a 401k, has group life insurance. And so, yes, you should do a will, because it begs the broader discussion of what about these other things?
So a will in that case would need to be done, though, with an attorney rather than some of the online options where you might not then
Well,
be thinking about all these
Right.
very
That
important
was my
related
next question.
issues.
Yeah.
Why do I have to do it with you?
Well, partly because there are certain things in life that you should not try to do on your own.
Yeah, I
and
agree.
I think that, you know, surely I can change the oil in my car, but I'm not going to rebuild my engine. And I think you can do pretty well, but it's what you don't know that'll get you.
Yeah.
So on the power of attorney, just a quick example. You can buy a power of attorney at Staples or OfficeMax for $10. It is the world's most dangerous document because it says, I name you to take charge of my financial assets. If you and your boyfriend take that document, you can sell my house, close my bank accounts, and be in Aruba in a heartbeat. As the lawyer, when I draft a power of attorney, I require that 2 physicians certify that you're no longer able to handle your affairs before anybody can do anything. So it is a very subtle yet very important distinction. And so, you know, estate planning, I have an office in Wellesley, a pricey town. The typical estate plan is not particularly expensive. For a single adult, it's less than $1,000. For a family, maybe $1,800. For the very wealthy, maybe it approaches $3,000. But all of it's measured to what we're doing. So to do a power of attorney, a healthcare proxy, a will is not a big financial commitment.
Well, especially when you think of what the success can look like versus the failure.
Absolutely. It's a huge swing.
Right. I mean, you know, I work with attorneys in a consulting capacity, so I hear about these successes and failures, and certainly don't have the depth of experience you do. But when even the few examples I hear about, or that I know about in my own life of success and failure, the difference is so dramatic. And I wonder, is this a good time for you to tell us about what success looks like and what disaster looks like? Because then the value of the $1,000 or the $1,500 comes to life very differently to me.
I think I would recharacterize it by saying peace of mind versus no peace of mind.
Okay.
What I sell for a living is peace of mind. Yes, it's a stack of legal documents that play out when something happens. It's not about success or failure, because the people you leave behind will have some feeling of having had an easy time or a hard time. And surely we could talk about success or failure in the context of millions of dollars of lost taxes or probate court guardianships because you didn't have a healthcare proxy. So there is pain along the way. But for the person who's sitting thinking about doing their estate plan, the issue is peace of mind. Because there are plenty of people who lay in bed at night worried that they haven't done their papers and they have young children. Or mom is 80, she has 4 kids, one of whom's in the throes of a bad divorce, the other is unemployed, and she can't imagine how to set up her estate plan to make it all better for them. Yet as the estate planner, I know exactly what to do to make it better for her. And if I spend 20 minutes with that person, she will feel enormously better because she'll know now I have a plan. So that's the difference.
So that success as when the person is alive and the